This is a presentation for the mediation and the due process hearing by Eva Maria Leonard, presenting for SPED 5314 at the Concordia University. In this presentation, you will be able to understand the following objectives. What is due process hearing? When is it appropriate to call a due process hearing? Who can request a due process hearing? And what if differences aren't met at a due process hearing? Special education, the mediation and due process. Mediation and due process hearings are two of the four procedures to achieve rights, make corrections, or come to an agreement regarding special education paperwork. They are found within the procedural safeguards that are found within the Individuals with Disabilities Education Act. Both of these are exercises that are meant to assist schools and the families reach a consensus regarding the student's education. Mediation, what it is. The mediation process is meant to prevent more severe legal or costly outcomes. In a mediation, a mediator is retrieved at random at the request of the families after there has been a disagreement on student identification, placement, or FAPE, free and appropriate public education. Both parties must want to participate in a mediation in order for it to take place. Mediation and how it works. The mediator does not make a decision at this meeting. They are trained to allow to give both parties a voice, make suggestions, or give feedback. If an agreement is made, they will sign on a written paper an agreement, and it is to be followed as a legal contract. This paperwork can be in turn presented at a courtroom if it turns into that situation. The due process hearing, what it is. A parent, school, or both may deny mediation ruling or simply follow a due process hearing without going through a mediation first. A due process hearing is similar to a court case with a prosecutor or a petitioner and a defendant or a respondent. Again, this process is only with disagreements regarding identification, placement, or fate. These are recorded as substantious violations. If the hearing is due to errors in process, such as regarding the process of meetings, invitations, prior written notice, or anything listed in IDEA, the violation is referred to as procedural. The due process hearing and how it works. When a petitioner requests a due process, then the respondent has 10 days to reply. This needs to take place within 1 year of disagreements. Within 15 days, a hearing officer must be notified. The hearing officer's job is similar to one of a judge. Both parties will then attend a pre-conference 14 days prior to the hearing to clarify the disagreement. 5 days prior, both parties must present any documentation, paperwork, or evidence they will present at the trial. The due process will last anywhere between several hours to several days. Due process hearing, how it works, continued. During the events of a due process hearing, the child in question is to remain in the last agreed upon placement. If the child is petitioning to attend a public school, then the child must be able to attend during the process of the due process hearing. At the end of the hearing officer has 45 days to come to a decision. In an expedited case, it's only 10 days. The education agency is responsible to make sure the hearing officer's decision is followed within the state of Texas. If either the petitioner or the respondent would like to appeal, they may appeal to a higher court, state or federal, within 90 calendar days. If the hearing officer decides in favor of the family, they may be entitled to reimbursement for attorney fees. Here's the format of the due process hearing. They begin by calling to order and giving reasons for the hearing. They continue with opening statements. Both parties, petitioner and the respondent, are able to demonstrate what will be presented during the hearing. Next is the presentation of evidence. Professionals and other witnesses are called under oath and are examined. Direct examinations, cross-examinations, and redirect examinations. Documents must be offered prior to and given exhibit names. Closing arguments. The petitioner and respondent are able to brief their evidence and make direct connection to their argument. Last, the case will be recorded. Within 2 weeks of the hearing, a free copy of the hearing must be provided to both parties. Here's the timelines of how the due process hearing should take place. Within 1 year of disagreement, there should be a due process requested. 10 days after the request, the respondent must reply. Within 15 days of the request, the hearing officer must be notified. 14 days prior to the hearing, there should be a pre-hearing or a pre-conference regarding clarification of the questions at hand or the disagreement. 5 days prior to the hearing, the evidence is offered and exhibited. 45 days after the hearing officer should have a decision. And within 90 days, a party should appeal to the higher courts. In conclusion, it is important to remember that these are not meant to deny or delay the proper placement of a student in the SPED program. These are only two of the possible resolution processes. These methods are meant to resolve conflict between the family and the educational entity. The mediation process is an attempt to prevent or avoid taking legal and formal actions at the cost of the families or districts. And either party has the right to appeal what is decided by the hearing officer and is able to be taken to higher courts, which are state or federal.